A baby dies, her mother pleads guilty to child neglect and is sentenced to prison time. Case closed? Not exactly.
A judge vacates her conviction. Her new attorneys say she's innocent and there was no crime committed, but the state isn't backing down.
Leading local KX News is digging deeper tonight into the case of Cassandra Black Elk in our top story.
This whole prosecution, from the moment she was arrested until the moment she pled, was substantially flawed.
When Cassandra Black Elk was arrested in February 2022, police alleged she was too intoxicated to care for her infant daughter, resulting in the baby's death. Black Elk eventually pled guilty to the crime, but testified in a post-conviction hearing that she was innocent, repeatedly asked to see the autopsy results, and was advised by her then attorney that pleading guilty was the best outcome. KX News reached out to Black Elk's attorney at the time of her guilty plea, but we did not hear back. A report of death obtained by KX News shows the autopsy findings were finalized just a little more than a week after Black Elk's guilty plea on May 16th. The report of death signed by Dr. Barry Miller showed the infant's cause of death to be unexplained sudden death, the manner of death, undetermined. In a letter to Black Elk's attorney, Dr. Mary Sins writes in part, quote, all four forensic pathologists at UND fully and unconditionally support Dr. Miller in this case. This death is not abuse. This death is a sudden unexplained death. We do not know what caused it or if this death could have been prevented, end quote. Dr. Miller performed the autopsy on February 22, 2022, the same day Black Elk was formally charged with child neglect, and testified at a court hearing that initial autopsy findings found no evidence of foul play or recent significant trauma in the infant. Miller also said there were several people present at the autopsy, including Burleigh County State's Attorney Julie Lawyer.
I don't want it to be lost on the court that at the time that the state presented Ms. Black Elk with this plea agreement, asking her to plead to the maximum of 5 years with all but 18 months suspended, it had knowledge for the last 3 months from the pathologist that there were no signs of injury to this child.
KX News reached out to Lawyer regarding that. In an emailed statement, Lawyer says in part, Black Elk was charged with child neglect and the state was required to prove she failed to provide proper parental care or control by consuming alcohol to a level that impaired her ability to care for her daughter, and her daughter died as a result. Lawyer states Black Elk was not charged with any crime that involved infliction of injury to the child. But in her review of the autopsy findings, Dr. Sins notes there is no objective quantitation for the allegation of drinking. This may have been minimal or excessive. It does not contribute to the death of this child. This death is a tragic, unexplained loss of an infant. This death could not have been prevented based on the knowledge we have today. Though a district court judge ruled in favor of Black Elk on an ineffective assistance of counsel claim and vacated her conviction, the state is appealing the decision to the state Supreme Court, saying the district court judge only relied on Black Elk's account of what her then attorney told her.
If we're judging an attorney's performance based on words he spoke, that we're now going to come in and say that those words were unreasonable, I feel like the safeguard of credibility, the way to guard credibility would be to just bring him in and say, what did you say? Why'd you say it?
KX News reached out to the Bismarck Police Department to inquire whether Black Elk's blood alcohol level was tested during the investigation into her daughter's death. A BPD spokesperson declined to comment since the case is on appeal. But at the state Supreme Court hearing, Black Elk's attorney says an affidavit signed by a BPD officer falsely attributed a statement to Black Elk regarding how much she drank the evening in question.
We have a statement in the affidavit of probable cause that is demonstrably false. There's an allegation that Ms. Black Elk admitted that she went to the liquor store that night and consumed more alcohol.
The state Supreme Court heard arguments in the case in late June, but has not yet issued a decision. Should the Supreme Court uphold the district court's decision to vacate Black Elk's conviction, she's scheduled to go to trial on the child neglect charge in September.